Okay. Irrespective of that, the Supreme Court, having not averted its mind to this amendment, has based its decision on that Federal High Court declaration and has upheld the fact that Section 142 is inoperative. So we as lawyers, we can only work with what the Supreme Court has said. Bearing in mind again that we can also provide the argument that the Supreme Court may have reached its decision by incuriam, having not averted its mind to the proper provisions of the law in terms of time of enactment with regards to the decisions that were...
Just quickly again, would you kindly say what the difference was? What was the situation in 2010 and what was the amendment that was made to that particular
In 2010,
yes,
the Federal High Court in Abuja decided that Section 140, subsection 2, that says that a tribunal can only order a rerun and not declare a second person as the winner of the election, was the Federal High Court declared that section as inoperative and as invalid and unconstitutional, being vague and against the provisions of the Constitution, specifically Section 239 and 285. That was the decision of the Federal High Court. Now, subsequently, on 31st December 2010, the National Assembly amended that same 142 and still specifically and expressly lifted that section 142 and superimposed it on the
same
amendment.
way.
It not necessarily the same way, with few dramatical changes, but with the same effect that all the court can order is a rerun.
And not declare
the person with the second highest vote.
And that should have been expunged.
If the National Assembly averted its mind to the decision of the Federal High Court, it should have expunged it. But if it decides not to have expunged it, it continued with it. It has still put it in our law. That means that it may also have averted its mind to that decision and still insisted that it should continue to be part of our law. But while that still exists, the Supreme Court still went ahead in a recent case in February 2015, Jeff and Iyotkom, to decide that the decision of the Federal High Court still subsists. And that raises a lot of questions. And I think it is upon the decision of the Supreme Court in February 2015 that the Tribunal in Taraba based its decision. And if it does so, you cannot fault it. What I would rather say that it would have led to also pulling the rug from under the feet of the people. Because if the people decided that it is this person they have voted for, I think democracy portends and
or the party
that they voted for. Democracy portends that the wishes of the people should be respected, and I think that the duty of the court would, in this regard, would have been to adumbrate, emphasize, amplify the wishes of the people. But in this case, it is against it. However, the law is as it is, in my view, that the tribunal may have acted according to what the Supreme Court has decided.
Which some people will say there's no confusion, because if the Supreme Court was of the opinion that that section 142 was against the Constitution, in the sense that it seemed to tie the hands of...
No, the Supreme Court was not of the opinion. The Supreme Court in that case...
upheld the decision of the Federal High Court.
Yes, the Supreme Court had earlier upheld section 142 that a tribunal cannot declare the person with the second highest vote as winner. But one of the parties averted the Supreme Court's mind to the fact that that section has been declared invalid, and therefore it's no longer operative. The Supreme Court now went back and reversed itself and upheld the decision of the Federal High Court as declaring that section invalid. But my point is that the Supreme Court also may not have averted its mind to the amendment of...
I get your point. What I'm trying to say is the amendment did not change in any way significantly what was there before now.
Yes, but what the Supreme Court's decision was based on was the original section upon which the Federal High Court held its decision. Note the date of the amendment, 31st December 2010, which means that...
Sorry to interrupt you, Mr. Ikeji.
Yes.
You know, I'm not a lawyer, and for a lot of people oftentimes amendments are done not on the basis of technicalities, on the basis of the content. There must be, you know, a basis upon which...
Yes. That is the mischief rule. In statutory interpretation, sometimes you look at the laws,
intendment.
The intendment. It may be that there's a mischief intended to be corrected by the National Assembly.
If that was the case, and it would seem that the mischief was not exactly corrected, the mischief in the sense that the hands of the court are still tied.
No. The hands of the court, if they had averted their mind to the date of the amendment, would still not have been tied, because it is a clear provision that the tribunal can only order a rerun. And that is 31st December 2010, the last day of December 2010, and that is an act of the National Assembly, and the words used there were clear. There is no need to start going behind the clear intendment or the clear use of the words of the court. The words used there were very clear.
Well, I've got some people who are also just asking here, saying, wait a minute, so if this turns out the way it is, with INEC testifying that no primary is held, many want to find out. So does that mean that INEC, number one, did not know that Darius did not rightfully emerge, or that did they try to observe the primaries and were denied? Just like
yes, I think it's funny that INEC should go back on its own representation. There are different principles of law under which this can be argued. For example, there's what you call promissory estoppel. If a person or a group of persons act based on your representation to them, you cannot go back on that representation. In other words, if INEC had, at the material time, brought out PDP candidate as the rightful candidate of PDP, that's the representation it has made to the people. And the people voted based on that representation. And INEC is now coming back to go back on its representation. There is a question on promissory estoppel, although it's an equitable relief, which you can only use as a defense when you are attacked.
Depending if it was before the tribunal at this stage.
And that's why I'm saying that it's a matter of argument. If it was before the tribunal, and a matter of evidence. If INEC had put the picture, I mean the emblem of a political party, PDP, on the ballot box and insisted that the people can vote for PDP, why should it come to the tribunal and give a contrary evidence? I think it should be held to its earlier word, even though the evidence before the court, we may not have appropriate...
if it shows otherwise.
Yes, there might be different evidence before the court.
All right, interesting perspective. Mr. Ikechukwu Ikeji is a legal practitioner. Thank you for your thoughts.
Thank you so much for having me.